This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the Chair of the inquiry, the Right Honourable Sir Justice Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending the hearing. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The first part of the order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the Chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the Chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. The second part of the order, which applies to the hearing scheduled to take place today, 11th October 2023, arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 10 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in that preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the Chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order.
Mr. Hermer.
Thank you, sir. Just to orientate everybody as to where I am, I'm in the fourth of the 6 parts of my submission, sir. I'm dealing with the adequacy of the RMP investigations. Having taken you to Sestro, could I now turn to Northmoor? In March 2014, around the time that Operation Sestro referrals were made to the SPA, but before a decision had been taken not to prosecute, Operation Northmoor commenced. So on the information and evidence that we have, including that taken for the purposes of the judicial review in which we sought expert assistance, it is our position that there is credible material before you that could well lead you to the conclusion that Operation Northmoor was deeply inadequate. It investigated only 4 of the more than 30 suspicious incidents, and it was hampered by its own limitations, principally its under-resourcing and lack of necessary investigative expertise. It took decisions not to pursue lines of inquiry and potential sources of evidence, which are very difficult to understand on their face, and in which, in some instances, would appear to defy logic and common sense. And although it was initially tasked with investigating systemic issues, its terms of reference were later changed to expressly exclude that from its work. But as with Operation Sestro, the progress of Operation Northmoor was thwarted by what you may ultimately consider to be deliberately obstructive conduct from members of the sub-units being investigated and their chain of command. And I've touched on some of that already, the documents reveal that relevant evidence was deleted in the face of repeated requests for investigators for it to be provided to them. Witnesses were coached by former SAS personnel or claimed collective amnesia about what had occurred. Incident reporting documentation was fabricated, and credible evidence, as I've already touched upon, that political pressure was applied to drop the investigation. Now, the investigation began with external advisors being appointed from the National Crime Agency and the Greater Manchester Police. Both organisations, as you would expect, steeped in experience and expertise in the investigation of serious organised crime, the most obvious analogy with the investigation that was warranted here. In 2016, following 2 years of investigation, with the assistance of the NCA and GMP, 2 British soldiers, the commander of Subunit 1 and a soldier within that subunit, who had described the deliberate practices of executing civilians, were designated and official suspects, and there were plans in place to arrest them on suspicion of murder in relation to the deaths of the Saifullah family. However, there was a very significant change in approach in July 2016 when Brigadier David Neal became the new Provost Marshal Army with overall responsibility for the conduct of Northmoor. At about the same time, the Ministry of Defence's Directorate of Judicial Engagement Policy created a new independent advisory group, the IAG, and the IRT, the Independent Review Team. Also at about the same time, in September 2016, the Operation Northmoor Gold Commander also departed unexpectedly through illness and was replaced by a new Gold Commander, John Harvey, appointed by the new Provost Marshal. For reasons that have never been explained to the families, once the IAG and the IRT were established, Operation Northmoor cut all ties with its previous advisors from the National Crime Agency and Greater Manchester Police, and there was an abrupt and radical change in the scope and approach of the investigation, culminating, after a brief review of Operation Northmoor by the IRT, in the recommendation not to arrest the 2 suspects. The reason for that recommendation was a supposed lack of evidence of wrongdoing and a concern that the original strategy might be damaging to morale and reputation. Shortly after their appointment, the 2-person IRT began making recommendations that, in their own words, were at odds with the direction given by the National Crime Agency. Over the 3 years that had been advising operations, given by that agency over the 3 years of advising Northmoor, in particular between the 5th of February and the 13th of February 2017, the IRT conducted a review of the investigations being undertaken by Team 1 Northmoor. The review was conducted to, and I open quotes, short timescales, close quotes, and it was, open quotes, not possible to examine all available material, close quotes. Notwithstanding that, after the brief 8-day review, on the 24th of January 2017, the IRT delivered a report which concluded that the information underpinning Objective Typhoon, the Saifullah incident, was, in their own words, untested, untried and without provenance, and of a poor quality and cannot support the contention that criminal offences have taken place. The IRT added that the suspect designations in connection with the 2 individuals are premature, without foundation, and at this current time profoundly unhelpful to the progression of Operation Northmoor. The IRT therefore recommended that the 2 individuals should no longer be designated as suspects, and these recommendations were all accepted and implemented by Operation Northmoor. The IRT advised open quotations, that there would be merit in obtaining an individual duty statement report from each participant in Operation Tyburn who is still in active service, close quotations. They did not, however, advise obtaining such statements for individuals who are no longer in active service, because this would, in their own words, involve, open quotation, a significant risk that unwanted media attention would arise, close quotation. The IRT at this stage advised that, open quotations, effort to recover data sets proceed by consent and not seizure in an effort to identify relevant material. Although the decision to abandon the covert strategy was said to be based on the lack of evidence of wrongdoing, it appears that it was also influenced by other extraneous factors, such as the likely effect of arrests on the service personnel morale and the reputation of the armed forces. A letter from the Ministry of Defence Permanent Secretary to Mark Sedwell, then the National Security Advisor, was dated the 2nd of August 2019. It, by way of example, explains this. The initial investigative strategy, following advice from the National Crime Agency and the Greater Manchester Police, was misplaced. This has been predicated on the basis that highly classified intelligence would be analysed through deployment of sophisticated ICT, and suspects would be identified. There's then a passage that is redacted, and it continues this, along these lines. This would have been extremely damaging to morale and reputation, and very probably operational effective, and, as it turns out, not justified by the evidence. In addition to the IRT's rejection of the investigative strategies advised by the National Crime Agency, the IAG also had some significant and surprising differences of opinion with the course taken by Operation Northmoor prior to their appointment. For example, the IAG was critical of the decision to interview a serving whistleblower. It said this: the Independent Assurance Group's view is that the decision to interview the whistleblower, who is still serving for intelligence purposes, was the wrong one. He should have been required to give a put-up or shut-up statement at the outset. So there are going to be many points that may be made in due course about the qualifications of those making those recommendations on the review board and their experience of serious organised crime, both in itself and in comparison to the National Crime Agency. I've already alluded to their report being based upon what might be thought, in the light of 3 years of serious advice from the National Crime Agency, to be a flimsy review. But you may also glean something from this entry. Here we have, in the context of the utmost serious allegations in respect of special forces, in which anybody knows about the difficulties faced with a wall of silence, in which they have somebody from within with deeply sensitive information that they want to impart as part of a detailed and complex criminal investigation. What's the response of the Independent Advisory Board? That whistleblower should put up or shut up. Was this, sir, you may ask in due course, the appropriate means of seeking to respond to a source willing to give evidence about potential grave breaches of the Geneva Convention in an exquisitely sensitive investigation? Put up or shut up. So the IRT then took the surprising decision to limit the scope of Operation Northmoor to the incidents identified in the TTP review, a decision agreed by the Provost Marshal, who directed the Northmoor investigators accordingly. That decision, you may consider in due course when seen in the round, was maybe thought to be surprising and illogical. The TTP review, on its face, did not purport to be a comprehensive or representative view of all or even most of the relevant suspicious incidents. On the contrary, it was confined to 11 incidents over a 4-month period. And those incidents weren't selected by reference to any particular set of criteria or methodology. As I explained earlier, you may take the view that the review appears to have been a deliberately calculated attempt to suppress rather than expose the truth. And you may take the view that that should have been obvious to Northmore investigators when they were making these relevant decisions. So the decision to use the scope of the TTP review as the basis for determining the scope of Northmore's investigation was in our submission open to impeachment as fundamentally flawed. The decision to use it as the lodestar of Northmore was accordingly inappropriate. And it was recognised from an early stage that this decision, the decision to focus only on a small number of incidents, was likely to result in no prosecution of any individuals. In July 2017, Mr. Ryan, the Director of Judicial Engagement at the MOD, informed the Permanent Under-Secretary of State for Defence, Stephen Lovegrave, that of this, focus is now on one incident, with the several others on the back burner in case anything emerges. RMP now have no suspects. Prospect for successful prosecutions looks slim. In turn, that conditions the investigative strategy and the expectations about when this may be wrapped up. Did bad things happen? Quite possibly, but no alternative to current approach. Little appears to have happened in the investigation until 2018, when a further decision was to investigate just 2 additional incidents, known as Objectives 1 and Objective 2, which I've described earlier. The failure to investigate the other incidents, you may consider, is quite extraordinary, given the suspicious overlapping circumstances and the clear patterns of behaviour that they show. In particular, as with the incidents in which the relatives of the core participants were killed, some of which overlap with these 8, there were material discrepancies between the number of deaths and the number of weapon seized, implausible accounts about the incidents, and contemporaneous concerns about them. So essentially, these investigative decisions that were made meant that Operation Northmore, far from investigating the 3 or more years of repeated apparent misconduct and extrajudicial killings, was confined to primarily looking at just 3 incidents which took place over a period of 9 days, involving a single rotation of a single subunit. With this narrow view, you may conclude that it had no hope of properly appreciating or identifying the systemic failures and the wider pattern of conduct that the evidence available to them disclosed. There also, sir, appears to have been numerous failures of Operation Northmore to obtain highly relevant evidence, even of the incidents that they did investigate. The inquiry will no doubt consider this in detail, but for now, can I identify 6 examples that on the face of the materials that we are in possession with concern what we would consider to be decisions that cry out for an explanation where none is apparent. So the first is this: the decision not to review full motion video footage of the incidents. Despite initial difficulties recovering the footage, there was a decision made to decline an offer from a long-standing partner to recover that evidence, inexplicable on its face. Second, the decision not to seek further information from Governor Mangle, who raised complaints in respect of several of these incidents. Third, the decision not to interview the Director of Special Forces or the in-theatre commander of the SAS unit, who, according to contemporaneous documents, had direct knowledge of suspected EJK and who coordinated the internal and external response to it, as you've seen from the documents. Fourth, the failure to interview Afghan witnesses until 2019, despite identifying relevant witnesses many years before that. The passage of time had a serious impact on the evidence available, and it would obviously, for example, have impacted upon clarity of recall. Certain witnesses now, so many years after, could not be located. Or, as in the case of the Afghan soldiers who accompanied the SAS on the night raid of the Norzai family, soldiers had either died or sustained injuries such that they couldn't recall. Fifth, the failure to investigate concerns raised by former weapons intelligence specialists that members of the UK Special Forces had planted weapons at the scene of fatal shootings, which were then photographed to support false accounts. No interview of that. Six, the failure to investigate other information and intelligence concerning possible unlawful killings, including information received from an asylum interview, an informant former British service person, or other members of the UK Special Forces. Now, all of these failings, you may find, having considered the evidence in the round, including evidence not in our possession, you may find stem from, in part or in whole, a lack of investigative experience and specialist personnel available to Operation Northmoor. A key institutional reason for this lack of experience and resourcing is the remit of the RMP. In particular, that the service police have little or limited experience of major crime, let alone of the magnitude that the evidence suggested may be present here. A related problem may be thought to be excessive deference was shown to the IRT, who themselves had only limited operational or military awareness, and who only spent a short period of time reviewing these materials. And these were problems that you may also conclude were compounded by the shortcomings in the number and high turnover of personnel deployed in Operation Northmoor. And it was all despite obtaining approval for a bespoke IT system required to process and review the vast amount of forensic and electronic and digital evidence. You want an insight into failures. The system was never installed or used. Crying out for it. Never installed, never used. Now, yesterday, in the course of his submissions to you on behalf of the RMP, Mr. Greenie, King's Counsel, referred to the observation of Sir John Murphy, the independent reviewer, member of the IAG, about the zealous approach of the RMP. He said in his statement to the judicial review that the investigators were zealous in their conduct of an extremely difficult situation. Sir John had also given evidence, although not referred to in his statement, to the Parliamentary Select Committee on the Armed Forces Bill in the previous year, in which he had highlighted the lack of experience and skill of the SIB, the RMP, in investigating even a single incident homicide, let alone allegations of the type the RMP faced in Northmoor. Can I just quote to you, sir, the evidence that Sir John gave to the Select Committee? He said this, open quote, "I found these service police to have many fine officers who were well trained and who want to, and in many cases do, a good job. But the reality of investigation within the service justice system is that instances of serious crime are extremely low. But when it takes place, it's the most serious type of offending and requires the skills of experienced and skilled investigators." So John went on. "Predominantly with the three issues that we have discussed, murder, manslaughter and rape, the workload is not high. Across the three services, each SIB investigator is called on to investigate approximately a single crime a year. When you compare that with the caseload of the civilian detective it is probably 100 times less. Consequently, through no fault of their own, they lack experience of the day-to-day grind that their civil counterparts have, of investigating many crimes and getting the experience that flows from that. That led to the context that I have described. And then Sir John said, I can give you an example of what I'm talking about. At one point I had a conversation with a senior investigating officer, the most important investigator, on a homicide investigation. I was discussing the merits of a particular tactic that he was adopting and questioning it. I asked him when he had done that, how many homicides have you investigated previously? His answer was, none, but I've done the course. Accepting that we all have to start somewhere, Sir John said, that gives no confidence or comfort to the families of victims that they're going to get justice. And the inquiry will no doubt want to bear in mind this candid assessment, as well as, we would hope, expert evidence from those who have real experience in serious organised crime about the approach that was adopted here and the deficiencies or otherwise of the RMP. Could I mention one other thing as an aside flowing from Mr. Greeny's submissions yesterday, because he also raised the creation by the Ministry of Defence of the Defence and Serious Crime Command, the DSCC, as a more specialised investigative force. And so you may wish to consider the efficacy of the DSCC insofar as you are going to address lessons to be learned as part of your mandate. But I regret to tell you that to date it has done nothing to instil confidence in the bereaved families. In May of this year, in written submissions placed on the inquiry website, the RMP informed you that there were further investigations underway in respect of a number of cases involving our clients. And following correspondence between Lee Day and the GLD, on the 20th of July, we asked the DSCC, on behalf of those clients, for information about their investigations and an opportunity to meet with them. And I regret to say that, save for a simple acknowledgement in a letter of the August the 7th, 5 letters, including reminders letters sent through from July to last week, have gone wholly unanswered. To put it mildly, if the DSCC does not deign it appropriate to have even the courtesy of acknowledging correspondence from the families of the victims, let alone informing them as to the status of the investigations into the deaths of their loved ones, it does not bode well. Could I turn then to the closure, sir, if I may, of Operation Northmoor? It was a decision made in the middle of 2019, and it was an abrupt one, shrouded in secrecy, and in respect of which, on the materials we possess, it is nigh on impossible to define an adequate basis. Whilst decisions taken in the course of an investigation meant that it was struggling to make any appreciable progress, it was clearly ongoing and had by no means reached any satisfactory conclusions at the point at which it was shut down. On the 15th of July 2019, the Provost Marshal Army, Colonel Neil, decided, and we can see here, that the statutory test provided for by the Armed Forces Act 2006, sufficient evidence to charge an identified individual with an offence, has not been met in relation to any of the allegations. The decision, we are told, was endorsed by the IAG, which was satisfied that all reasonable and proportionate lines of inquiry have been pursued. The decision has been endorsed by the Director of Service Prosecutions. Remarkably, it may be thought, the logic was that the conclusions on Objective 1, 2 and Tyburn indicated that further investigation of the other instance was not worthwhile. The investigation was closed before all the evidence had been analysed, before members of one of the relevant subunits had even been interviewed, and while investigators were still in the theatre, meaning that, in the words of Operation Northmoor itself, large-scale strategic decisions were made before evaluation of evidence had taken place. Operation Northmoor came just 3 days before Colonel Neil was replaced as Provost Marshal, following completion of his 3-year term. The timing of the closure, coupled with the fact that certain lines of inquiry remained outstanding when the investigation was terminated, is capable of suggesting to the objective observer that the final stages of the investigation were rushed or not completed at all in order to enable Colonel Neil to terminate Northmore before he left his post. And this may be an issue that the inquiry will examine. What is noticeable is at this time, specific concerns were raised by the Minister of State for Defence, Mr. Mercer MP, who, it was reported, was unconvinced that there had been no wrongdoing at all within Operation Northmore, and it was reported, expressed concern that Operation Northmore had been closed. Johnny Mercer MP, it is reported, stated that he believed we would eventually be compelled to reopen this. The inquiry may wish to consider the basis for the minister's concern, a minister who has always been in public quick to defend the military and to cast doubt on the integrity of those who have criticised it. But in this instance, the inquiry may wish to consider what it was that led him to express such clear concerns. Can I turn next within Northmore, sir, to the destruction of evidence and interference with the investigation? Because the available evidence would suggest that the limited investigations that were carried out in Northmore were obstructed by 3 further significant issues. Firstly, UK Special Forces higher headquarters in the United Kingdom destroyed and impeded access to relevant evidence. Secondly, witnesses were coached and documents were fabricated. And thirdly, improper pressure, political pressure, that I've touched on before, was applied to investigators. And may I take those in turn? First, at an early stage of the investigations, Operation Northmore identified the need for full recovery of data held on what is known as the ITS-1 system. That's the main IT network used by the higher headquarters of UK Special Forces. And it was noted that this was the only course of action available to provide for an effective investigation. And this was the reason for that was because the server would be likely to hold key information essential to the investigation. As the senior investigating officer explained, the server hosts all the operational information relating to Special Forces operation, and there was therefore an immediate requirement to forensically recover the server in order to best preserve data critical to the investigation. As early as 2015, a specialist advisor at the National Crime Agency was stressing that it was, open quotes, absolutely essential that there is no further delay to enable search retrieval of key information, close quotes. 2015, National Crime Agency. In early 2016, the senior investigating officer produced an official policy record which made it clear that one of the key decisions why it was essential for Northmore to recover the server was that it contained electronic correspondence and records of key individuals at Special Forces higher headquarters who played main roles in the TTP review process. Those key individuals included in particular the Director of Special Forces at the time of the review. The crucial nature of material on that computer system and the imperative to recover it in full could not have been made clearer at an early stage of Northmore. Notwithstanding that, sir, there is evidence capable of showing that Special Forces higher headquarters took repeated steps to avoid, delay, and frustrate the provision of that data requested by the Royal Military Police. They initially opposed providing Operation Northmore, giving it at all, and then agreed to do so before again reneging on that agreement. Now, given the importance of the evidence held on the server, the senior investigating officer was eager that the RMP use their legal powers to seize the data. That's what you would expect in any equivalent civilian investigation. But his requests for authorization to seize were repeatedly rebuffed by his superiors in the RMP. An official policy records that from August 2016, that instead of ordering the seizure of the server, the Operation Northmoor Gold Commander, and I open quotes, directed that we attempt to recover the data set amicably. The Provost Marshal, i.e. the head of the RMP, likewise stated that he wished to maintain, quote, wished to maintain analogue, which I think must be dialogue, with the headquarters before this in an effort to reach an amicable solution. In December 2016, the Gold Commander told the senior investigating officer that he was aware that the recovery, quote, of the system would be deeply unpopular on behalf of the UK command, i.e. the Director of Special Forces. From the perspective of the RMP's most senior officers, the conclusion that one can draw from this may well be that maintaining warm relationships with Special Forces headquarters and keeping the commanding officers happy was more important than the prompt and full recovery of the vital evidence. So no doubt in the course of the work of the inquiry, there's going to be comparison made with what would have happened if this was an equivalent civilian investigation into allegations of murder or other very serious crimes. And no doubt differences can be drawn because of the nature of the military and in particular the nature of special forces. But let there be no doubt at this stage what was being investigated, which was allegations of unlawful killing. And it is clear that straightforward requests for the provision of what investigators identified as essential data for obvious reasons, you don't need to be a criminal investigator to understand that, were being blocked. What would have happened in an equivalent civilian murder investigation? Would it have been a decision to try and resolve this amicably and not come in and seize the material? There's only one answer, obviously, to that. In late 2016, sir, Operation Northmoor formally directed that UK Special Forces headquarters were not to delete, amend, move, or otherwise alter any of the data in ITS-1 server. And they were provided with a written assurance to that effect. However, when Operation Northmoor technical staff visited the location when the server was held, a short while later, they discovered that the data had been deleted from it 2 weeks prior to their visit, after the assurance that it had been retained had been received. In a record dated the 12th of December 2016, the senior investigating officer described how UK Special Forces headquarters have deleted material from the preserved server. The deletion process has been conducted in such a way that it is irreversible and impossible to determine what has been deleted. This is in direct disobedience to our demands to preserve the data in its entirety and the headquarters agreement that they would do so. So self-evidently, the defiance of an unequivocal direction to retain evidence is at best highly suspicious, and at worst a patent and criminal attempt to pervert the course of justice in a multiple homicide investigation. Indeed, this is exactly what the senior investigating officer thought. He identified several possible causes of action, which included pursuing an offence for perverting the course of justice, an intentional effort, he said, to prevent the RMP access to relevant material. He added, either people responsible are held to task or permitted to go and check. Quite. So you are going to receive some further evidence on the server in a forthcoming hearing. And you will no doubt want to look at that in the round, not least the other occasions during the history of the events that you are reviewing in which data has gone missing. And you will no doubt wish to identify the steps that were taken to preserve that documentation, not just from the moment the assurance was given that it would be preserved, but from the very point, many, many months beforehand, in which the investigators had made plain they wanted access to it. Now, following the discovery that data had been irretrievably deleted from the server, the senior investigating officer again urged the Goals commander to authorise the RMP to seize the remaining data. He emphasised that, in his own words, this, open quote, anything less would fall short of a thorough and effective investigation, close quote, and further, open quote, that any delay in recovery risked the loss of evidence and the ability to conduct a prompt and effective investigation, leaving the inquiry and the RMP open to criticism, close quote. Once again, the Gold Commander refused. But that's not all. Not only did the Gold Commander refuse to permit seizure of the server, he expressly refused to explain the basis for his refusal to his senior investigating officer. Contemporaneous documents reveal that the senior investigating officer was puzzled and deeply troubled by this refusal to permit the RMP to seize evidence which was clearly recognised to be essential to the RMP's ability to conduct an effective investigation. But so events become murkier still. Not only did the Gold Commander refuse to permit the ITS-1 server to be seized in order to preserve whatever evidence remained after the unauthorised deletion, and not only did he refuse to provide any explanation for what we would contend is a baffling decision, he also ordered the senior investigating officer not to attend a forthcoming meeting at Special Forces headquarters at which the issues of deletion of data and recovery of remaining data were to be discussed. And even more troubling, sir, layer upon layer, he ordered the senior investigating officer not to investigate the circumstances of the deletion of the data from that server. Matters that the officer thought may give rise to charges of perversion of the course of justice. Precluded from investigating it. And that on its face, on the available material that we have, would appear to be a truly remarkable and inexplicable direction. After months of stonewalling and obfuscation, Special Forces headquarters had apparently defied an express order from Northmoor to preserve all data, yet rather than investigate how and why it was deleted, the senior investigating officer was expressly forbidden from inquiring at all. And as a result, Operation Northmoor never recovered the ITS-1 server or investigated the deletion of the data from it. And instead of which, they continued to seek access to the evidence held on the server by consent, i.e. with the permission of Special Forces headquarters. Their request for access to material on the ITS-1 system remained outstanding at the date that Operation Northmoor was closed down. So we would respectfully submit that these events cry out for explanation and investigation, not least for three important reasons. Firstly, the deliberate destruction of data in these circumstances, if upon investigation seen in the round that is what you conclude it is, or that there is credible evidence that that's what it is, would be a prosecutable offence or perverting the course of justice. Secondly, you may conclude that there would be no reason at all for deliberately destroying innocuous data. So you may conclude that the reasonable inference to draw from its deliberate destruction, or I say deliberate destruction, or a mindful failure to secure preservation, that such steps would reflect the existence of highly relevant material on the server. Thirdly, the failure to take proper steps to obtain the servers by the RMP is powerful evidence at best of the ineffectiveness of RMP. And insofar as the directions not to investigate the circumstances of the deletion, at worst, it may share the same common intent by some to cover up the conduct that Northmore was charged to investigate. So what is perhaps even more troubling is that this is not an isolated incident. When in 2016, Operation Pavo, which was the investigation, as I've said, into the killing of an Afghan detainee in September 2010, was referred to Operation Northmore, SAS headquarters staff forensically wiped a laptop, I'll give you the quotation from the document, the day before the RMP had the opportunity to recover it in pursuance of the inquiry, close quote. The Operation Northmore senior investigating officer observed in respect of that, open quote, the deletion of evidence immediately prior to recovery by the RMP is coincidental at best. At worst, this may be deemed suspicious, close quote. And the inquiry will need to consider, we would respectfully submit, how and why the deletion of this essential evidence occurred and who was responsible for it. It will also need to consider the reasons for the RMP's failure to exercise its powers to seize the remaining undeleted data and for failing to investigate whether the deletion was part of a deliberate attempt to destroy evidence of wrongdoing. The second significant hindrance experienced by Operation Northmore, so I've dealt with servers, was the apparent regimental amnesia and question of coaching of witnesses by UK personnel, meaning that interviews with implicated personnel were often of little evidential value. And the reference to coaches of witnesses implies a concerted, in our submission, or at least provides a proper basis for suspicion of a concerted effort to cover up. Witnesses being encouraged and coached by retired members of the special forces to withhold the truth. There are numerous references, sir, in the contemporaneous records to senior special forces commanders and Operation Northmore investigators being aware of statements and official incident reports being cut and pasted from each other. And the reliability and availability of evidence, we would suggest, would be naturally seriously hampered by these practices. And the inquiry may well wish to investigate whether Special Forces personnel did seek to coach witnesses and whether the RMP took appropriate action to investigate and prevent this. And the inquiry may also well need to examine whether the evidence of regimental amnesia and cutting and pasting of incident reports were part of attempts to cover up. So we've been here before with regimental amnesia. This is not the first inquiry into allegations of misconduct. And you may well reflect upon the experiences of Lord Justice Gage in the Baha Musa inquiry, faced with a wall of "I do not know, sir, I cannot remember, sir." Cutting through that requires enormous skill and expertise. You would have seen that Judge Advocate Brereton managed it in Australia. It required serious, seasoned, experienced investigators in Northmoor. So can I turn to the third component of concern, which was the significant concern that the conduct of Northmoor was impacted by improper pressure being exerted on senior investigators to ensure they did not investigate the issue of command responsibility of senior commanders, including the Director of Special Forces and the in-theatre commanding officer of the SAS unit concerned. And so we've been here before, time and time again, in which focus is often exclusively focused on those on the ground, but not those who provide the orders. And in this case, it is not mere speculation about pressure. An internal RMP email dated the 25th of September 2017, by way of example, referred to the previous Gold commander, i.e. the immediate subordinate to the head of the RMP, having reported in May 2016 that he was placed under political pressure to focus on investigating tactical level command responsibility. The clear inference is that to the extent command responsibility was to be investigated by Northmoor, senior investigators have been placed under political pressure to focus on inquiries of at the tactical level, i.e. the level below the Director of Special Forces and the in-theatre command of the SAS. In other words, this appears to be contemporaneous evidence of improper pressure being exerted on senior Northmoor investigators to ensure they did not investigate the command responsibility of senior commanders. And the inquiry will therefore, we would respectfully submit, need to investigate whether, and if so, how, when, why, and by whom such improper pressure was applied, and what its effect was on the course and outcome of Northmoor. So I turn now to my fifth subject, which is the continuing cover-up during the judicial review proceedings. The concerns that I've expressed in respect of cover-up to date extend to the conduct of the Ministry of Defence in respect of the claim for judicial review brought by Mr. Cy Fuller. Now, before I address this topic, sir, it's important for me to make absolutely clear that we recognise, of course, that the inquiry is neither a vehicle for relitigating the judicial reviews, nor a forum for addressing grievances about the professional conduct of the MOD's officials and representatives in those proceedings. We understand, obviously, that we are no longer litigants in the administrative court, but core participants appearing before an independent statutory inquiry. And although the inquiry is the direct product of that judicial review, we recognise that attempting to engage in arid point scoring about what occurred in those proceedings will plainly not help your inquiry to discharge its essential statutory functions. And the submissions that I'm about to make are advanced with that responsibility very firmly in mind. But the inquiry's terms of reference do include the issue of cover-up. In short, did people within the MOD, with knowledge of the truth about the existence of suspicions of deaths caused by special forces during the relevant period, did they take deliberate steps to prevent that truth from coming to light? And as I shall explain, sir, this is a question which cannot properly be investigated and answered without considering, in due course, the MOD's stance and conduct in the Cy Fuller judicial review proceedings. In a nutshell, the bereaved families contend that the extraordinary evidence that has emerged over the period of several years of litigation demonstrates that officials within the Ministry of Defence deliberately sought to try to prevent the truth, namely that bereaved families were possibly murdered by members of the SAS. They sought to prevent that ever from seeing the light of day, And they did that by putting forward a case in the Saifullah judicial review, which they knew was false, and which they knew was directly contradicted by damning contemporaneous evidence, of which those officials were fully aware of. And this is not an allegation, sir, that we make lightly. It is, however, an allegation which is supported by cogent evidence. And it is an allegation, I respectfully submit, that falls squarely within your inquiry's term of reference. And we respectfully submit the inquiry must, in due course, fully investigate if it's to effectively fulfil its terms of reference and command the confidence of the bereaved families and the public. Now, in order to place the events concerning the Saifullah judicial review in context, it's necessary to begin by understanding that in 2014, Mr. Saifullah and his relative Mr. Bang issued a civil claim for damages against the Ministry of Defence, alleging that their relatives were unlawfully killed in the raid in February 2011. So that claim was ultimately settled. The terms of settlement are confidential, but it has been agreed that they can be provided to your inquiry. But it is now apparent that in the course of responding to the civil claims, the Ministry of Defence officials and lawyers located, obtained, read and analysed numerous documents, some of which I've shown you today, which clearly suggest that Mr. Saifullah's relatives were innocent civilians murdered by the SAS. What is more, those documents demonstrate widespread contemporaneous knowledge within UK armed forces of the possible unlawfulness of the killings at the time at which they occurred. Now, after that civil claim was settled in 2018 and Operation Northmoor terminated in July 19, on the 23rd of October of that year, 2019, Mr. Saifullah issued his judicial review claim. The claim alleged that Mr. Saifullah's relatives, the deaths of Mr. Saifullah's relatives, had not been investigated promptly or effectively by the RMP. And in respect of that, their legal case was that Article 2 of the Human Rights Act required an effective investigation. In respect of promptness, no investigations into the death were begun until March 2014, more than 3 years later, Northmoor. In respect of effectiveness, Mr. Saifullah alleged that the RMP had failed to conduct an adequate investigation of the systemic issues, including very much whether the deaths of their relatives were part of a broader pattern of unlawful killings rather than simply being an isolated incident. And the premise of both the promptness and the effectiveness grounds of challenge was that the suspicious circumstances of the deaths of Mr. Saifullah's relatives were widely recognised at the time and formed part of that much larger pattern of suspicious killings that I have alluded to. So the claim was issued. 1 month later, on the 25th of November 2019, the Secretary of State for Defence served his acknowledgement of service in accordance with the rules of court, which was curiously unsigned, together with his summary grounds of defence. The response robustly opposed the granting of permission. It stated, in clear and unqualified terms, that there was no good reason for the RMP to have opened its investigations prior to March 2014. So that's the point at which Mr. Saifullah's uncle raised the complaint via his solicitors. It also stated, nor did the claimant or anyone else make a complaint to the RMP that the 4 individuals had been unlawfully killed. Now, we subsequently know, of course, at this stage we have no documentation at all. There's been no disclosure, obviously, as you all know, sir. The benefit of hindsight, one can see that statement was literally true, but obviously highly misleading. It was true that a complaint wasn't made to the RMP in 2011. However, as I explained, this wasn't because no contemporaneous complaints were made. Of course, they were. wasn't made to the RMP at the time because of a deliberate and concerted decision by the senior British officers, army officers in 2011, including the senior lawyer, not to refer these complaints to the RMP. And the statement that there was no complaint to the RMP deliberately ignored and concealed these vital facts. They pleaded as a basis to reject the claim. Neither the claimant nor anyone else made a complaint to the RMP that 4 individuals had been unlawfully killed, in the knowledge, as I will show you, that complaints had been made, including to the governor of Helmand. Complaints had been made, and then they were not forwarded to the RMP. So that's their summary grounds of defence. And so, as you know, in judicial review proceedings, once the summary grounds of defence are served, the matter goes normally on paper before a single judge of the administrative court to consider whether or not permission should be granted to allow the claim to proceed. And so it happened here. And in light of the Ministry of Defence's written response to the claim, application for permission to judicial review was refused by William Davis, Mr. Justice William Davis, as he then was. And that decision was premised on the judge's understanding, based upon the contents of the grounds of defence, that on the material available to the defendant, no investigation was warranted until 2014. The judge added in his written reasons that the argument that the defendant's own officers should have referred the matter to the RMP assumed that those officers have recognised that the deaths required investigation. This is to ignore the reality of the position in the relevant part of Afghanistan at the time, concluded the judge in his reasons for refusing permission. As I shall explain, far from ignoring the reality of the position, the claimant's case fully reflected the reality, as the MOD's officials and lawyers well knew at the time permission was refused on the papers. Mr. Saifullah then exercised his right to renew his application for permission at an oral hearing, which was held in early March of 2020. And at that hearing, the Secretary of State's position, once again, both in writing and orally, was that the claim was unsupported by evidence and was unarguable. 2 key points were advanced on behalf of the Secretary of State. First, his leading counsel told the court in no uncertain terms that there was, open quote, absolutely nothing, close quote, to suggest that the MOD's officers should have recognised that the deaths of Mr. Saifullah's relatives required investigation. Second, leading counsel stated that here there was, open quote, no evidence at all, close quote, to support the claimant's allegations of a cover-up, which was nothing more than, open quote, a sort of no smoke without fire general inferential analysis, close quote, which was, open quote, based upon nothing more than inference from anonymous media sources, close quote. Similarly, in submissions advanced in writing, the Secretary of State told the court, for example, that, open quote, the claimant's attempt to bolster his claim by reference to media reporting of other incidents and general speculation to the effect that there may have been some form of cover-up of a pattern of unlawful killing during military operations in Afghanistan should be rejected, close quote. So all of this was completely untrue. Indeed, the implication that the claimant's case was little more than a speculative conspiracy theory could hardly have been further from the truth. As subsequently emerged, at the time when these statements were made to the court on behalf of the Secretary of State, the Ministry of Defence was already in possession of, and its officers and officials were directly aware of, contemporaneous records which demonstrated that far from there being no basis for suggesting MOD officials should have recognised the need for investigation, in fact, multiple officers and senior officers were aware that the deaths of Mr. Saifullah's relatives were highly suspicious and ought to have been investigated. Those documents had been summarised, the documents, many of which you have seen, those documents have been summarised in a note which was provided to the Ministry of Defence Council by a government lawyer before the summary grounds of defence were filed. Those documents included extensive expressions of concern about the incident and others like it, including expressions of concern by senior members of UK Special Forces, some of which we've seen today, the Afghan Armed Forces, the Afghan government, and the reputable international organisation. And there was also substantial evidence that the truth of what occurred had been and was being covered up. So we say that it is difficult to conceive of a more seriously misleading position than that which was put forward by the Ministry of Defence in its attempts to close down the Saifullah judicial review. Fortunately for Mr. Saifullah, and indeed for all the other bereaved families, and we would say the wider public, Mr. Saifullah was able to persuade Mr. Justice J that permission should be granted, albeit on a limited basis. That success, which was achieved by the skin of its teeth and in the face of vehement opposition by the MOT, is the reason that we are here today. Had Mr. Justice J followed Mr. Justice William Davis in accepting the Secretary of State's position that there was no evidence supporting the claimant's case, then it is certain that this inquiry would not have been established. It is certain that the thousands of pages of deeply concerning documents about possible Special Forces war crimes would have remained locked away in filing cabinets and classified computer servers at the MOD. Now, the MOD accepts that it misled the claimant and the High Court in the Saifullah proceedings. However, it denies that this was intentional. Its position may perhaps be summarised by cock up, not cover up. But as I'll explain, that explanation does not withstand scrutiny. The evidence points firmly in the direction of an intention to deceive the High Court into refusing permission, with the inevitable result that the very serious evidence of extrajudicial killings and cover-ups would never see the light of day. In short, sir, the evidence suggests an attempt, which very nearly succeeded, to cover up the cover-up. What's the basis for such a serious assertion? The answer lies in the evidence that emerged in the weeks, months and years following the grant of permission by Mr. Justice J. 4 months after permission was granted, in July 2020, the Secretary of State disclosed a tranche of documents which showed extensive contemporaneous expressions of concern that Mr. Saifullah's relatives had been unlawfully killed and the disbelief that, about the official account of the incident. Again, we have seen some of those documents before you, sir. They include the email sent by a senior British officer just hours after the incident, which referred to it as the latest massacre, and in which derided the official account of the incident. You couldn't make it up in capital letters, pointing out that it was a continuation of an implausible set of descriptions of similarly suspicious fatal shootings. The documents disclosed in July 2020 also include emails that record senior Afghan military officials and senior Afghan military and governmental officials expressing immediate concerns after the Saifullah incident about the killing of innocent civilians. And they include an email expressing concerns about the possible existence of, I quote, a deliberate policy to engage and kill fighting-aged males on target even when they did not pose a threat, close quote. In other words, the deliberate policy to commit war crimes that I have outlined. Now, the significance of these documents is obvious. As Mr. Justice Swift, who managed the public law litigation, observed at a hearing in July 2020, the documents are clearly critical to what Mr. Justice J regarded as the most important issue in the case, and what, on any analysis, is the most important issue in the case. So, remarkably, it transpired that the existence of these damning contemporaneous documents was widely known amongst the MOD's officials and legal representatives at the very time at which it was vehemently opposing the granting of permission in the judicial review, seeking to close it down. After this tranche of documents was disclosed, Mr. Justice Swift took the unusual step of ordering the Ministry of Defence to provide a witness statement explaining how its position that the case was unarguable came to be advanced. And that statement was provided by a Mr. Benjamin Saunders, who is was the Deputy Director of the Directorate of Judicial Engagement Policy at the MOD. Mr. Saunders was, in his own words, open quote, responsible for the coordination and oversight of the defendant's response to this claim for judicial review within the Ministry of Defence, close quote, and he personally, open quote, approved the final draft, close quote, of the Secretary of State's ground of defence. He was, in short, in charge of the MOD's response to the judicial review. So I would submit that when you come to consider this matter, you will find the contents of Mr. Saunders' statement seen in the context of the materials available as shocking and extraordinary. It revealed three things amongst many. Firstly, by the time that the Secretary of State for Defence was preparing his response to the judicial review, Mr. Saunders was personally, open quotes, was aware that concerns about deaths during deliberate detention operations, including this specific incident, had been raised, and that a review of the specific TTP had been conducted in 2011, close quotes. Mr. Saunders was, open quotes, alive to the fact that these would be highly relevant to the issue of whether the scope of the RMP investigation had been sufficiently broad, adequately to investigate the alleged systemic issue of a wider pattern of similar incidents. Close quote. Indeed, not only was Mr. Saunders aware of these matters, in October 2018, he had actually been provided with copies of some of the documents themselves. And in September 2019, a GLD lawyer wrote to him specifically highlighting other contemporaneous documents which would be, open quote, problematic for the MOD, close quote, in this context. Mr. Saunders admits in his statement that it is likely he reviewed those documents following that message. Second point arising from Mr. Saunders' statement is that it reveals that at the same time, the MOD's advisory lawyers, referred to by the acronym Modeler, were, open quote, aware of the TTP review and of the general internal concerns regarding the activities of the unit that had given rise to the review, close quote. Modeler, sir, are co-located within the MOD and, open quote, were involved with the private law and public law claims, close quote. Third point from Mr. Saunders' statement. It reveals that both the solicitors and counsel acting for the Secretary of State in the Saifullah Judicial Review were repeatedly made aware of the existence and contents of these critical adverse documents, adverse to the Ministry of Defence's case. A solicitor at the GLD prepared what was titled a close note, which contained a gist of quotes from a number of documents. She shared her concerns arising from those documents with the GLD lawyer dealing with the public law claim in a number of conversations within the MOD. The closed note was provided to the Secretary of State's leading and junior counsel in the Saifullah proceedings. Leading and junior counsel both expressly confirmed they had read the closed note before the Secretary of State's defence was filed. Not only that, leading counsel also received copies of the documents themselves, together with instructions which expressly referred to, open quotes, the fact that contemporaneous concerns were raised about the operations conducted by the particular unit in question, close quote. In summary, therefore, sir, Mr. Saunders' statement revealed that at the time when the MOD was vigorously seeking to persuade the High Court that there was no evidential basis for allowing the Saifullah Judicial Review to proceed, the MOD official responsible for the conduct of the Saifullah litigation, the MOD's legal representatives in that litigation, the MOD's internal and advisory lawyers, they were all aware of the existence and contents of a plethora of documents which directly contradicted the false case which the MOD was advancing before the court. And that, we would submit, is cogent evidence of a continuing cover-up by the Ministry of Defence. The Ministry of Defence response to the judicial review was, in short, there's nothing to see here, and the claim must be thrown out at the earlier stage, was completely unsustainable in light of the documents known to Mr. Sanders, who had conduct of the litigation, and the MOD's internal and external lawyers. So the story doesn't end there. As the inquiry will be aware, the 30 pages or so of documents which were disclosed in July 2020 were merely the tip of the iceberg. They were subsequently followed by approximately 6,000 pages of documents disclosed between late 21 and late 22. And I've already explained that disclosure contained a vast number of documents which supported Mr. Saifullah's case. Significantly, the disclosure in 21 and 22 also contained internal documents produced, received and exchanged by Mr. Sanders and his superior, Mr. Ryan, the head of DGEP, in the period while the Secretary of State was vehemently seeking to have the judicial review dismissed. The contents of those documents we would submit are impossible to reconcile with the position that was simultaneously being advanced at the same time by the Secretary of State of the Administrative Court. For instance, on the 8th of October 2019, less than 3 weeks before Mr. Saifullah issued his judicial review claim, Mr. Sanders sent an email which recorded that the Minister for Defence, People and Veterans, Mr. Mercer, MP, and you'll see the quotes, has some very specific worries and a firm belief that something went wrong with these operations, and he finds it difficult to reconcile the outcome of the investigation with the APU's dissatisfaction with this TTP. So expect detailed questions on the TTP review and a broad concern about the potential for evidence to emerge after any announcement that investigations are complete. Some of this stems from his time in Afghanistan. In particular, he appeared unconvinced by assurances that there's no video footage for the operation that resulted in the death of 4 relatives of Bang and Saifullah. Mr. Sanders went on, sir, to make plain that he had persuaded the minister to keep quiet about these concerns in order, it appears, to prevent the Saifullah judicial review from succeeding. Mr. Sanders wrote this: I think we persuaded the minister that any acknowledgement, as part of an announcement that investigations are complete, that things went wrong in operations in Afghanistan, would be prejudicial to our ability to withstand litigation and to defend the threatened judicial review of Northmore. On the 31st of January 2020, after the claim was issued, and a few weeks before the renewal hearing before Mr. Justice Jay, Mr. Sanders sent an email to Mr. Ryan in which he stated that the MOD's Systemic Issues Working Group, SWIG, would need to start, and I quote, reviewing all incidents involving fatalities and potentially also serious wounding during deliberate detention operations. Ideally, we should resume this work before the permission hearing in Saifullah. He added that the issues which would need to be investigated include the conduct of UK Special Forces in Afghanistan and the investigative and prosecutorial response of the RMP and the SPA to those alleged unlawful killings and covers-ups. Mr. Sanders observed that investigating these issues would require examination of why there was an apparent failure to report the incidents to the RMP and why the service justice system has proven incapable of achieving accountability. On the 21st and 25th of February, this is after permission has been refused, and it's a fortnight before the renewal hearing, before Mr. Justice Jay, Mr. Ryan sent emails to various officials at the MOD which referred to the need to conduct some serious lessons learned work, which is important both for substantive reasons and because the likelihood that the RMP investigations will be challenged in court via judicial reviews, the others being Norzai. Mr. Ryan attached a document entitled Lessons from Operation Northmore, in which he explained this. A number of the incidents investigated, I quote, showed multiple Afghan fatalities with bodies in close proximity to one another. Some incidents showed a high ratio of bodies to weapons recovered. Explanations adduced for this included fratricide, and in some cases the same weapon being picked up by different individuals, as and when the previous holder had been shot. In a number of incidents, the explanation for an Afghan fatality was that the individual had been sent back into the compound to ensure no one was present. The individual then allegedly picked up a gun or grenade and was shot when he reappeared. Mr. Saunders goes on. Frankly, many of the explanations appear highly questionable, if not actually implausible, not helped by the practice of post-mission cut and paste statements. The RMP was sceptical, Mr. Saunders said, about some of the supposed fire sites which left all the Afghans dead with little evidence of captured Afghans with a weapon when surrounded by a large number of heavily armed UK and Afghan security forces, and was not something they'd heard of in any other circumstances. And there were no UK armed forces fatalities. The same SNCO was present on a number of operations. And in his lessons from Operation, I should just reflect a moment ago. So this is after permission has been refused on the papers on the basis of the summary grounds, and before the MOD were preparing to come into court to try and argue that permission should remain refused at the oral hearing, because there was no evidence, pure speculation, media reporting. So in his Lessons from Operation Northmoor document, Mr. Ryan also discussed this, open quotes, the outstanding issue of how we handle systemic issues from Operation Northmoor, a court requirement. He noted that questions are likely to be raised about the scope of Northmoor, which was, in his words, quite narrow. He went on, in particular, only a proportion of the large-scale shooting incidents over the period 6 months in 2011 were investigated in any detail. So this is Northmoor he's critiquing now, sir. And there have been no investigations of earlier Special Forces deployments, during at least some of which even more Afghans were killed, again with relatively few weapons being recovered. Mr. Ryan added, the TTP review commissioned seems unduly focused given the strength of insider concerns. And Mr. Ryan acknowledged the possibility that these issues would need to be examined in a public inquiry. He said this, at this stage, we cannot rule out the imposition of a public inquiry or an Afghan fatalities inspector along the lines of the Iraq model. These documents were sent, sir, and received by the senior MOD official in charge of the Saifullah litigation and his superior. And many of them were expressly concerned with the Saifullah litigation and the MOD's response to it. But at the same time as all this evidence of deficiencies and suspicion was being recognised in their internal correspondence, the Ministry of Defence was unequivocally assuring the court that there was no evidence to support Mr. Saifullah's claim of a pattern of unlawful killings and associated cover-up by UK Special Forces. At the same time that the MOD was assuring the court that it had adequately and effectively investigated all relevant systemic issues, Mr. Ryan and Mr. Saunders were expressly discussing the various ways in which it had failed to do precisely that. And at the same time as the MOD was telling the court that there was no prospect of it, that a new investigation could achieve anything beyond that which had already been achieved by Northmoor, Mr. Ryan and Mr. Saunders were acknowledging both the shortcomings and the limitations of Northmoor and the issues which would need to be investigated if those shortcomings were to be remedied. While repeatedly telling the court that the case was hopeless, Mr. Saunders and Mr. Ryan were repeatedly acknowledging the contrary. So the story of this judicial review proceedings is, on any view, a sorry one, but it is, I am afraid to say, a deeply suspicious one, concerning the withholding of key evidence and the advancing of patently untrue cases that go to the very heart of whether the MOD had properly investigated whether the SAS were engaged in a pattern of war crimes and cover-up. If the suspicions about the MOD's conduct of the judicial review are well-founded, as we submit the evidence I've outlined suggests that they are, then the cover-up with which this inquiry is concerned extends to an attempt to mislead the High Court and to impede the fair functioning of the justice system. It goes without saying that any attempt, if established, by an organ of the state to prevent scrutiny and exposure of its wrongdoing by knowingly advancing a misleading case to the High Court would be a grave affront to the rule of law and a serious assault on the bedrock of trust and honesty upon which our system relies. It is therefore, we respectfully submit, sir, imperative for your investigation of cover-up to encompass these questions. I don't suggest for one moment it should be where your inquiry starts, sir. But cover-up is part of your mandate, and there is prima facie evidence that there has been a cover-up here. And it should form part of your fearless investigation into the matters arising.
Mr. Hermer, given the hour, should we take a 10-minute break?
Of course, sir.
If that would be a convenient moment.
It's a perfect moment. I've got one section left.
Indeed, for the shorthand writers. Thank you very much. Let's reconvene, please, at, say, 20 to 4, 15 minutes.
Thank you, sir.
All right? Thank you. Yes, Mr. Hermer.
So thank you. Before I turn to my sixth and final part of my submissions about culture and lessons learned and secrecy, could I just finish my last section by referring to some recent evidence that has been obtained by your inquiry that demonstrates that the RMP have received more recent information about allegations of extrajudicial killings by the SAS in Afghanistan. And those are allegations that were not previously known to the bereaved families, but have emerged from the witness statement obtained by your inquiry from Colonel Rothschall, who is a senior RMP officer, and his statement is dated the 14th of September 2023. And we understand, sir, that your inquiry will shortly take evidence from Colonel Rothschall. But of particular interest and indeed concern to the bereaved families are the matters that are contained in paragraph 264 of the Colonel's statement, in which he identifies three more recent allegations of serious crimes being committed by the Special Forces. And can I just take you to those three instances highlighted by Colonel Rothschall? First is one in October 2020, where we are told that an allegation was made by a serving officer that between 2010 and 2011, he was not only informed of, but observed UK Special Forces employing a policy of shooting unarmed nationals and then altering the scene to make them appear as combatants. Colonel Rothschall says and tells us that an investigation was commenced with the complainant, who was unable to provide any further information or offer tangible evidence. A second potential witness could not substantiate the complainant's account or offer further lines of inquiry. The investigation did not identify any suspects, and the investigation was discontinued after consultation with the SBA. Then we're told that on the 10th of February 2021, a complaint was made directly to the Provost Marshal Army by a serving senior officer relating to the professionalism, we are told, of UK Special Forces personnel. The complaint alleging that the senior officer had been informed by the commanding officer of the deployed Special Forces unit that an entire subunit had been returned to the United Kingdom as a result of partner forces being unwilling to work with them in June or July 2012. We're told by the Colonel that an investigation considered all reasonable lines of inquiry, but it didn't reveal any evidence to support the allegation. It didn't identify suspects, and after consultation with the SBA, no further action was taken. And then on the 3rd of May of 2022, the headquarters of UK Special Forces outlined that in July 2018 and January 2020, a serving Special Forces soldier had disclosed to family members that he had shot and killed a child whilst on previous operations in Afghanistan. And during the investigation, the Colonel tells us that two potential civilian witnesses to the disclosure refused to provide evidence. The RMP concluded that the evidential standard wasn't met, having consulted with the SBA, and no further action was taken. So 3 points need to be made on a preliminary and provisional basis, because of course you will be hearing from the Colonel. First, as a result of Colonel Rothschall's statement, we now know that there have been recent disclosures by serving members of the Special Forces indicating that they know of or had witnessed unlawful killings of Afghan civilians. Second, it appears from the information that is contained in the Colonel's statement that once again these allegations appear to have been investigated by the RMP in a siloed fashion. There's no suggestion that the allegations were considered in the light of other similar allegations with a view to seeing whether or not they form part of a pattern of unlawful behaviour. And third, just as with all the other R&P investigations, these allegations have been closed without any prosecutions being brought. And the inquiry may well need to examine these recent allegations in some detail, together with the RMP's response to them. This is not least because of the identity of the individuals concerned. These are complaints coming forward from serving British military officers in the Special Forces, and the fact that they include at least one individual who told the RMP that he had actual first-hand knowledge of murders by the Special Forces in Afghanistan. It's also because the RMP's allegations, a response to these allegations, appears on its face to have troubling echoes of what we would term the overly myopic approach that characterised Northmore and Sestro, siloing. But the bereaved families, sir, are encouraged to learn that serving military personnel continue to proactively come forward to give evidence of wrongdoing by UK Special Forces. And so it is our belief that those coming forward now will receive a more proactive response from this inquiry than has ever been received by the RMP. And that will be for a range of reasons, not least the undoubted high level of professionalism and experience of your team, who, if I may say so, represent the creme de la creme of the prosecution bar in this country. And so those coming forward with evidence will have the knowledge and guarantee that it is going to be dealt with by people with skill and determination. It's also, sir, because your inquiry is not limited to a binary question as to whether or not there is sufficient evidence in one case or another case to prosecute for murder or perversion of the course of justice. You are taking, for the benefit of this country, a much broader view, applying different legal standards and legal tests to uncover whether there is credible evidence of the matters that fall within the remit of your inquiry. And for those reasons, sir, I repeat now what I said at the outset. Whether for king or country, whether for the rule of law, whether because it is just the right moral thing to do, anybody with further evidence that has yet to come before you should come before you now through the sensitive means of outreach that you, sir, and your inquiry have created. Sir, could I turn to the sixth and final part of my submissions, which is addressing what I suspect would come at the end of any work of your inquiry, which is the questions of institutional culture, secrecy, and lessons that might be learned. Because, of course, your terms of reference include considering what further lessons can be learned. And in our submission, the exercising of lessons includes very much an examination of the prevailing institutional culture within the Special Forces units, at least at the time in question. If, as the evidence we have seen to date appears to indicate there was a pattern of wrongdoing, of unlawful killing and cover-up, then it's essential to understand the institutional culture that enabled that wrongdoing to occur and to continue unchecked. An investigation of institutional culture must necessarily extend beyond the investigation of the particular facts and responses to particular incidents. And quite apart from the evidence that I've summarised today, the disclosure from the Judicial Review contains alarming documents which point to a wider culture of lawlessness, operational misconduct, failure of leadership and disrespect for basic human dignity within the SAS unit in question. And that evidence includes reports of a policy of blooding in new members of special forces, of inter-subunit rivalry and competition in respect to the number of kills achieved on operations, the collection and retention of trophy weapons, and the presence of indecent images of children on the server of the unit in question, which may be thought of itself a revealing insight not only into the members of the unit who possess those materials, but the timidity of those charged with investigating that uncovered, undoubted criminality. It also includes serious expressions of concern and anxiety by the RMP that there was what they term a very real, a serious, a credible and viable risk that members of the SAS would subject the family of whistleblowers to violent reprisals. As one senior special officer put it, it was though, open quote, a cancer had infected, close quote, the unit. This evidence disclosed in the judicial review, which is of course likely to be the tip of the iceberg of the materials that you and your team see, sir, strongly suggests a disturbing, lawless and morally corrupt culture pervaded at least some of the units in question. And in order to effectively learn lessons for the future, the inquiry will need to ask how and why that toxic culture was able to take root and to continue unchecked. And this will require considerations of issues such as leadership, training, monitoring and oversight. And the issues cannot be properly examined, we would submit, sir, without considering the role and impact of the secrecy in which the activities of UK Special Forces are shrouded. Don't think there's going to be much debate that secrecy about operational tactics and techniques will be necessary to safeguard national security and preserve operational effectiveness. But the wider secrecy surrounding the activities of UK Special Forces may also have had a potent and untoward side effect. Secrecy can operate as a shield to external scrutiny and accountability. And it can imbue those with a veil of secrecy with a sense that they are special, that the ordinary rules of conduct and norms of human behaviour do not apply to them, and that they are unlikely to be held accountable for their conduct, however reprehensible that might be. Secrecy can therefore lead to a sense of exceptionality and impunity. And a sense of impunity can in turn enable a culture in which human life and dignity are devalued and in which insidious values and behaviours take root. In short, sir, while secrecy may be necessary in respect of certain types of Special Forces operations, it may well also act as a catalyst for the type of toxic culture and behaviour which ought to be anathema to the UK's armed forces. And so therefore, sir, in our respectful submission, recognising the sensitivity and delicacy of the task, the inquiry should examine the institutional and cultural factors which, subject of course, sir, I should say, to the findings that you make about the substantive allegations, both on the operations and on cover-up, but subject to that and your findings on that, you should investigate and deal with the culture of secrecy and the downsides of that for the Special Forces. So can I conclude on behalf of the bereaved families by reiterating their gratitude to you and to your council team. They look to you to carry out what they hope to achieve throughout their years of tireless effort to seek justice for their relatives. A robust, and so far as possible public, comprehensive investigation into what happened to their relatives and the wider pattern of unlawful killings and cover-ups that took place during the relevant period. As I explained at the outset, the bereaved family priority is to uncover the truth of what happened to their loved ones and why it has taken so much time to achieve some degree of accountability. It's of course not possible to bring their loved ones back, but it is possible to test the integrity of the justice system in this country and to demonstrate both within the United Kingdom and in Afghanistan, and indeed worldwide, that we as a country will not tolerate unlawful action by our armed forces, and where there is credible evidence of unlawful behaviour, that our system will fearlessly, independently and effectively investigate it and seek to ascertain the truth, whatever that might be. Sir, we thank you for this opportunity, and of course we remain willing at all times to assist in so far as we are able with the work of this inquiry.
Thank you, Mr. Hermer, and your entire team. Before we adjourn, I want to conclude this opening session with a few remarks. Nobody who has sat through the last 3 days of opening statements could be in any doubt as to the gravity and scale of the allegations with which we are dealing and which form my terms of reference. Nobody who has sat through the last 3 days could be in any doubt as to how potentially damaging these allegations are, so long as they remain unresolved, one way or the other, and how corrosive to the reputation of the military, but also to the UK's international standing. Nobody can be in any doubt as to the necessity of this inquiry in the public interest, the importance of establishing the truth, one way or the other, and the importance of doing so with appropriate thoroughness. The longer these allegations remain unresolved, the more corrosive and difficult they become. And nobody who has heard the 262-paragraph opening statement of counsel to the inquiry could be in any doubt as to the extent of the very troubling material, including contemporaneous emails and complaints that is already in the inquiry's possession, having been disclosed in the judicial review proceedings. There have been a lot of fine words about supporting and cooperating with the inquiry. There has been a lot of talk about sharing the aspiration of the inquiry to get to the truth as soon as possible. There's been quite a lot of store placed on the number of documents disclosed in response to Rule 9 requests. But frankly, this is not enough. What is required, as the Chief of the Defence Staff and the Permanent Secretary have clearly said, is proactive cooperation with the inquiry by all military and civilian personnel alike. What proactive cooperation means is all those who have relevant information should come forward and contact the inquiry as soon as possible and not wait for somebody to contact them. What proactive cooperation means is positive action by all those who are in a position to direct, influence, or tell those who have or might have relevant information to contact the inquiry as soon as possible. Mr. Glasgow KC's opening speech has been put up on the inquiry website today. It should be compulsory reading, in particular paragraphs 51 to 210, for all those in positions of authority and influence in the serving and retired community, and who care about the reputation and future of our special forces, who should tell, or encourage those with relevant information to contact the inquiry straight away. As you've heard, the inquiry team have established secure methods of getting in touch directly, which are outlined on the inquiry website. Let me finish by echoing what Mr. Glasgow said on Monday on behalf of counsel to the inquiry. The length of this inquiry will depend entirely on the level of cooperation that we receive. If the MOD and the military are true to their word, if they engage with the process collectively and individually, and if they help to uncover the truth, then this work will take far less time than if we have to compel the production of evidence and the attendance of witnesses. And let there be no misunderstanding. This inquiry will use all the powers at its disposal to get to the truth. It will use all its powers to ensure that if there is credible information of wrongdoing by anyone concerned, no matter how senior their position, they are referred to the relevant authorities. And this inquiry will use all its powers to ensure that anyone who seeks to frustrate or impede the progress and conclusions of this inquiry will be prosecuted. And however long it takes, this inquiry will establish the truth or otherwise of these allegations in the public interest. We'll now adjourn, please, until Monday, the 23rd of October, when open witness hearings will begin in this court, Court 73 in the Royal Courts of Justice, and the first witness will be the Chief of the Defence Staff, Admiral Radikin. Thank you.